Good afternoon, everyone. Thank you. I was actually happy for you to keep that last slide up there if you wanted, because I too want to thank the organizers for inviting me, and especially I want to just thank my friend and colleague Fahad, who, in addition to being one of the organizers, has been sort of one of my teachers along the way, and so I really appreciate his ongoing engagement with me as I stumble into some of the conversations you're having. I say stumble because, I come to this venue feeling a bit like a poser. So and let me explain why I think that. So I trained as a medieval Islamic legal historian, and I was very happy writing about 9th to 15th century legal issues, of which maybe 15 people might read a book of mine. But then when I came to Toronto as a young, recently graduated PhD student and assumed a role at the faculty, Faisal, my other good friend here, reminded me that I got embroiled in the big debate here in Ontario around the Ontario Sharia debate, and had to really think of how is it that someone like me could be leveraged into this conversation. And I do say leverage because I think it's fair to say in 2005, when I was hired, that I was part of that wave of academic hirings on issues of Islam related to the war on terror. So I oftentimes tell my students that I'm very much a war on terror hire. And I got tenure knowing that, understanding that. And so part of what I've been doing lately is reversing that gaze a bit. And so, but from the vantage point that I tried to bring as a historian. And so while so much of the conference centers around Islamophobia as a racial category, I'm thinking with the language of critical race theory, I'm not a theorist in that way, but I come at it more as more rhetorically, the Muslim as a rhetorical figure. And so I'm actually trained in rhetoric at, that's where I did my undergraduate. I like to tease my parents who hated the fact that I was in rhetoric. I made it even worse by saying, well, I'm getting a BA and BS. And in many ways that was somewhat true, but it's also kind of like, it's also informed how I think about what I do with my training. And so part of what I wanted to say is, I come to this conversation with all of you from the angle of thinking about the historical construction of the Muslim subject, for whether it's in the medieval Islamic period, the medieval European, or now more recently through law. I also wear a law hat. And so I wanted to share with you two projects that I've done that speak to the general theme of the panel of sort of the proliferation of national security logics. And what was interesting for me has been always in looking through whatever archive I was looking through, to identify what are the different tropes, what are the different maneuvers, and figurations of the Muslim or of Islam, and how is it being deployed in any given context. So rhetoric becomes a significant feature of my analytic approach. So when writing about the Toronto 18, looking at the Asad Ansari's case, Asad Ansari was one of those convicted. We were able to locate the trial transcripts. They're all in 4 boxes in the basement of Osgood Hall, the courthouse. And my then graduate student and now co-author of the article spent hours pouring through this material to identify those sites where notions around Islam or area studies or whatnot feature into the conversation, noticing that there was a complete absence of evidence. There was a complete absence of expertise in the entire case, where even a government CI, paid as he was, ultimately $300,000, effectively became the expert for the court on issues of Islam, Islamic studies, radicalization, and complex area studies questions in the Middle East and Afghanistan, with the defendant, Asad Ansari, having to move back and forth between defending himself and also being an expert of his own. And of course, none of them were experts. For me, I think I wanted to spend more of my time really thinking about the report that we released in March of 2021 on the CRA and its audits of Muslim charities. Because as I was talking to Reem, I was thinking what would be the most useful here in this context to share with you, and really thinking about angles on research design, research development, and playing with your archives. So I'll spend a few minutes on that, and then I'll end with some sites of proliferation that I'm worried about, and I'll share with you as possible future research topics. So with the CRA report, that actually started out at a meeting that actually Faisal and I were at. I'm not sure we're allowed to talk about it because we did have to sign NDAs, but I think in the spirit of this conference, we'll all violate our NDAs. But it was with a number of charities that were really scared about the CRA. And the meeting was about trying to identify a platform or an agenda of advocacy at the political level. And the meeting ended with an ask of all the charities of about $250,000 or $200,000 to help advocate in a sort of government relations sort of way. And I was struck by that. As an academic, I was like, why do you, I of course and enjoy the luxury of being an academic, paid to sit and research. But for advocates and PR folks, they need to get paid for that. But 200,000 from the very charities being targeted seemed a little bit extreme to me. So that's what sort of prompted me to learn a little bit more about this story. And it was really challenging. But for us, it was about really trying to calibrate research design with the lived experience of communities. In this case, though, it was when you ask, and all the doctoral students here will know, when you do your prelims and you do and you get ready to write that dissertation proposal, the first question you're asked is, well, do a lit review. And then using that lit review, find the gap in the literature on that you can identify your specific novel contribution on. Well, in this case, there was no lit. There was maybe one MA thesis written and electronically published at the University of Alberta, but on Canada, there was nothing. And where there was research on the regulation of charities and the auditing of charities, there was nothing on the audits themselves. It was sort of like, here's a litigation on Holy Land Foundation, and there was analysis of that and the impact it had on the lives of those affected. Or here is the Interpal decision over in the UK. And it was always the end result of an inquiry, but it was never sort of a forensic analysis of how did the inquiry take shape? What did the audit look like? And so what we had an opportunity to do was develop an account of effectively, how does bureaucracy work? How do you normalize certain kinds of biases through evidence selection and interpretive bias as regulatory agents with administrative authority, which in Canada gets a lot of leeway? How do they act? And so it was about government actors acting on what biases. So we were fortunate to get 3 charities, all of whom had their charitable status revoked. Now, this is an important point. Originally, the design was as follows. We would work with charities that had been revoked, and we would do that on the record. We assumed that they would have ethically no concerns with that or limited concerns. And then we would do a confidential survey, an anonymized survey with charities currently being audited, and we would work through their lawyers who would preserve their anonymity due to solicitor-client privilege. And then we would work with a third set of charities who were not under audit, but wanted to talk to us nonetheless out of concerns or anxieties around how they were nonetheless reallocating their funds to account for the possibility of an audit, opportunity costs, right? Well, we never got those 2 latter categories. We could never get a charity to come and talk to us anonymously or through their lawyer. The fear of the CRA was huge. And of course, it affects the business model. If you are running a charity, you rely on those donations. If there's even a hint that you might be under audit, let alone a scrupulous audit like the ones we looked at, your business tanks. So there was an economics and a labor and economics element to the silence that we have to recognize. And so we were very fortunate to have those 3. So what does the archive look like? And so this is for the doctoral students here thinking about, as you imagine your archive, we had 3 administrative fairness letters, 1 for each organization. But and this was where the CRA would articulate, well, in the course of the audit, we have made these determinations and recommendations, and here's why. But appended to that audit or to the AFL are a series of appendices. In the case of IRFAN Canada, I want to say there was about 150 appendices. In the case of the Ottawa Islamic Center, I want to say 50, but I'm guesstimating. And with the Shia Assembly of Canada, the Islamic Shia Assembly of Canada, I would say another 50. So I would say about 200 to, if I've done my math, 200 to 250 appendices. And these appendices are untitled. Oh, there's no byline. There's maybe a title, Appendice A on X issue, but there's no byline. So it means there's no ownership of the research. So that is the faceless bureaucracy of the CRA and the Charities Directorate identifying what constitutes research for their purposes. And so the idea was there is no way we can prove systemic bias. We have 3 samples. That's not enough, right? We have 80,000 charities. 30% of them are roughly those that advance religion. We can't do systemic bias. And when you deal with the fact that ATIP produces nothing, we're still waiting for an ATIP request from the CRA years later, and privacy interests of other organizations, protect them from having to disclose things. We knew we could never prove that. So you have to be okay with that. You have to be okay. You have to figure out another way. And so what we thought was, well, let's use the appendices, of which we have approximately 200, as a sample set. And let's just see what the appendices do. And that's effectively what the report is. It's a review of what counted as evidence, what didn't count as evidence, what never got into evidence. And it was a review of where are their sources. So a lot of it was footnote analysis. If you're a law student, and work on a law review and you do those site checking exercises, which are horrible and tedious and annoying, well, this is where it pays off, because you're checking every single footnote. And just to give you an example of one that I'd love, this is my favorite example from we didn't publish this particular case, but it is one that we found. So there was a concern around the Muslim Brotherhood. And there was a citation in one of these appendices to an article in a journal. So, but it was an online journal, or at least it was an online DOI. So we went to the URL and we found out it wasn't a journal article at all. It was a blog. And it wasn't a journal at all. It wasn't a journal. It was a web page with a blog. You look at the editorial policies and there aren't any. And then you find out, well, who's funding it? And you look at there's a foundation listed. So I just correlated the foundation with the list of Islamophobia purveyors in the United States, and there they are. So this is just an example of one footnote in one report, and it just multiplies after that. So all of this is to say, the report does get criticized by tax lawyers and others for not proving systemic bias, to which we say we didn't try to prove systemic bias. We tried to prove evidentiary selection bias in modes of bureaucratic analysis under the regime of administrative authority. But to the doctoral students here, what we found incredibly important, and it became illustrated in the report that was released a month later by ICLMG, is being able to footnote your claims becomes extremely important. And so ICLMG ran into a little bit of trouble because they made an argument about RAD, the Research Analysis Division, and the percentage of Muslim organizations subject to a RAD national security review under the Charities Directorate. And they may very well be right, but there's no footnote. There's no evidence. There's no way to prove it. And it became a contentious issue for them and those who would otherwise want to rely on the report. So backing it up with evidence is key. Of course, the problem is, what if the evidence doesn't exist? And so what I'm now trying to think about and think with all of you through is, how do you address those areas that we suspect are sites of national security creep, Islamophobia, but in the absence of any evidence? And so your work on AI is really important to me, because I'm really interested in financial intelligence now. When you look at the way the CRA operates, it was deciding on which charity to audit for anti-terrorism purposes because it was getting reports from FinTrack, or at least we assume it was getting reports from FinTrack. FinTrack reports on collects reports from our banks on what are called suspicious transactions. The Proceeds of Crime, Money Laundering, and Terrorist Financing Act here in Canada not only creates FinTrack and expands its mandate from money laundering to include terrorist financing, but conscripts our banks as soldiers in the war on terror who utilize AI technologies, machine learning to assess and scrape our accounts for certain flags that are pre-programmed, I presume, but I'd have to talk. So I immediately, when I heard about his book, it's on my Amazon shopping list now, because I feel like I need to read that book. But there is a way in which what you're talking about is directly implicated in this national security creep in a way that now precludes people from even having bank accounts. I know there was an article recently on debanking. And if you're a bank and you issue a suspicious transaction report, as you're required to do under the PCMLTFA, FinTrack may do nothing with it. It might literally sit on it. But if a bank collects it and keeps it on file, it might choose to do something. It might choose to de-risk. It might choose to remove you as a client. And what we're finding is banks like HSBC, RBC, and others are now de-risking Muslims to the point where there is a hashtag called banking while Muslim. And it was actually invoked by Rashida Tlaib of the House of Representatives in letters to Wells Fargo, where she and members of Congress in the US raised concerns about this creep of national security into basic financial access to the financial services. So just imagine trying to pay without a credit card, not having financial access. The EU is interesting because they do allow as a right access to financial services. They might restrict it for national security purposes, but you can have a bank account. And yet here we are in Canada with limitations. And so I want to just conclude with a last remark around this proliferation issue, because I think that there are concerns. So my biggest concern on the banking is, how do you find the evidence? Where is the data? And it's not, you can't find it. I've talked to enough financial compliance folks to know that they won't talk to me. They can't talk to me. They're required to keep their products safe and sound, and for both national security purposes, but also intellectual property considerations. So for me, number one, rhetoric comes in where I'm interested in focusing on the Muslim, not to prove Islamophobia, but rather to interrogate democratic accountability. So that's a different positioning than perhaps we've been talking about. But the last point of proliferation I want to address is about a year and a half ago, maybe 2 years, Public Safety came out with a new national security screen for any of us applying to Tri-Council funding. I don't know how many of you are familiar with this. If you're a researcher in Canada applying for SSHRC funding, and you want to have a partnership with a foreign partner anywhere else in the world, you have to go through your university's national security screening process. And about, I want to say in 2020, Waterloo University invited CSIS, which was pushing out this agenda, to present it to VPs of research from across the country. And it was the first time I'd ever been invited to a forum where the opening speakers were all CSIS director generals and agents. And they were speaking about the wisdom of this policy. Of course, the wisdom of the policy was explained around patents, technology. The concern is Canada is ranked 17th in the world in patent production, in patent preservation, of course. And as we now are trying to build out an AI technology, so U of T has $100 million in the Schwartz-Reisman Foundation, which also supports the Lone Soldier program, but they're creating an innovation hub, and for $100 million. And so this is not an American thing. This is right here in our backyard. So the idea is, let's suppose so the idea is, number one, it's framed around China and its attempts to pirate or otherwise steal IP. That's the concern. So if you are a computer science professor with a contract with Huawei, how do you pronounce that? The Chinese company, Huawei, you're automatically suspect. If you're a Chinese national working in computer science, you're going to be suspect. We run a CSIS hotline at U of T, and the moment that public safety policy came down, within 9 months, our first case that we had since then was, of course, related to a Chinese national doctoral student in the natural sciences, working with someone who's in the computer science. So there is that creep. It's the China creep. But as they were presenting, it became obvious that they themselves are unwilling to acknowledge their own creep. The creep here is, at the same time we were meeting, we had hosted at the university a panel on Palestine. And one of the speakers was from one of those 6 organizations that Israel declared a terrorist organization. And we paid her $500. Technically, I violated a policy, assuming, of course, Israeli intelligence becomes Canadian policy. And so when we think about proliferations, I'd like us to think about the way in which now we've securitized our economy. But at the same time, it's already built into our intelligence saving and our intelligence sharing perspectives. The Comity of Nations does a lot to determine whose intelligence do we listen to and what deference do we give to them. In the Irfan Canada case, there was direct evidence from the Palestinian National Authority that Irfan Canada was doing amazing humanitarian work. Now, it came in after the internal appeal process, so effectively was ignored. But in the file that we had from Irfan Canada in the revocation process, the intelligence that they relied upon was American and Israeli. They never actually produced anything from the Palestinian National Authority. So all I want to suggest is proliferation into the economy is something we need to think about, and proliferation in the way we think about international relations, information sharing, and deference is another that I'd like to put on the table for us to consider. So thank you all very much for your time.